Hello, guys. Hello. Welcome to the Intellectual Property and Trade Nexus podcast. Today, we will be going through our second episode, discussing an overview of the patent law. We will be discussing uh, specific topics related to patent law. We want to know what is patent. We want to know what is an invention. So we will be basically discussing an overview of the patent laws. So welcome to our second edition, our second episode. You're all welcome. Thanks for following. Thanks for the support. Just want to take a minute or two to do a background check and to see if everything is going well with the audio, audio visual output. So in terms of the video quality as well as the audio quality, we are going to do a little check. Uh, okay. So let me do off. Check, and to see how we are going, how we are moving with this. Okay. I think this okay. So I can adjust the camera to the adjustment. Okay, so far so good. Let me look at follow-up. I want to play some music, but this is not going as planned. Welcome to the IP and Trade Nexus podcast. Thank you for following. We appreciate your support. We want to ensure that we remain connected with you guys, providing the best quality of this podcast. So thank you for always following and being supportive. So let me check out the okay. 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 Let me check it out from here. So let me check it up from here and see if the So me check it up. Okay. We're coming to great feedback with the sound, great feedback with the audio quality. So we can begin our. We can begin now by starting this. Okay, that is good. That is good. Okay. This is great. Okay. So welcome to the Intellectual Property and Trade podcast. This is the Forum for Innovations and Trade. Here we discuss intellectual property. Here we discuss international trade regulations. We discuss WTO laws. We discuss WIPO treaties. We discuss the multilateral trading system and all things intellectual property, all things international trade. So we want to say welcome to wherever you are following us from. Welcome to the Intellectual Property and Trade Nexus podcast. This is where intellectual property links or connects with international trade. Uh, I want to say good day, good morning, good evening, good afternoon, wherever you are following us from. Thank you for joining us. Welcome to this podcast. We would like to begin. Shortly, I would like to say I'm your host, Tom Baker. I will not go deeply into the background, but I think for the next three episodes, I think it will be expedient that I do a brief background information for those of you that don't know me and want to and will be following this podcast because I will be sharing it on YouTube, Instagram, and other social media platforms to ensure that we share our ideas, our experience and expertise in the field of intellectual property and international trade worldwide with you guys and with our audience. So I would like to briefly state that I've had a background in international trade, working formerly with the Ministry of Commerce and Industry, Republic of Liberia, and also working closely with WTO, the World Trade Organization related regulations, laws, and guidelines. So I worked at the Ministry of Commerce and Industry and serving as Assistant Director for Price Analysis and Marketing, and also serving as Intellectual Property and Trade Policy Analyst, working on intellectual property management, promotion, development, and protection. How do we enforce intellectual property rights uh, at the domestic level? Back in Liberia, we work closely with the Liberia Intellectual Property Office to ensure that uh, all rights and privileges given to rights holders within the territorial confine of Liberia. How do we promote, how do we protect those rights, how we promote intellectual property, and from the Ministry of Commerce perspective, how do we foster uh, trade facilitation, how do we foster domestic trade, how do we foster international trade as a member, a full-fledged member of the World Trade Organization. So briefly, I worked uh, uh, also with the World Trade Organization through an internship where I did had the opportunity to work directly with WTO related issue, working with thematic working groups, trade facilitation, WTO accession, uh, subsidies and countervailing measures, uh, patents, intellectual property protection. And so I would like to share my experience, my knowledge and expertise gained over the years, although I'm looking forward and moving forward to a brighter future. But while in that process of pursuing a brighter career or future moving forward, we also like to take it upon ourselves to share knowledge. And this is the process of sharing knowledge. This is a platform for sharing knowledge. Knowledge specifically related to intellectual property and trade. So let me go, not to waste a lot of time, but to go quickly into the subject to be discussed today. Today we will be looking at the overview of patent law. So the first episode, or what I refer to as my debut episode, we discussed the historicity of the patent and the patent system. So that was the first episode. Today we'll be looking at an overview of patent law and looking at specifically what is patent and what is an innovation. So to begin quickly, patent patents are very special rights that are given to inventors, innovators, creators. But they are basically, on a global perspective, there are two perspectives related to patent protection. And these two perspectives are of the American and the European perspective. These are the key perspectives that we use to protect patent or to provide patent governance. There are other approaches to patent protection in other countries, but these are the major ones that most countries are using. So these are the system, the American system and that of the European system. So we, what, make it almost adjustment. So what is the significance of patents? What makes patents special? What makes it relevant to the forward march of society? So patents are very relevant to our society and globally to the progress of society because of technological process. Uh, it enables any nation, any people or society to make advancement in life sciences or in specific fields that are critical to the forward march of any society. So patent is critical to, like I said, life sciences, health, uh, pharmaceutical, telecommunications, transportation, nearly everything we do as a society, there are some attachment or involvement of patent facilitating the progress we made, the technological advancement as a society that we are making. So patent is very critical to the progress of any society, of any nation and people. So patent is a very fast moving field, is a very flexible field. There are a lot of new creations that is being produced annually, every 3, 4, 5 years. There are new creations being produced. Now we are speaking about artificial intelligence that is very critical to the forward march in every country, every nation, be it through the American system or the European system. They are cultivating and crafting policies and regulations to ensure artificial intelligence is uh, governed in a way that benefits society, that there should be an equilibrium set, that we can obtain the best outcome from artificial intelligence, from biotechnology, from nanotechnology, and from all other new technology that is being created on a very fast pace. So patent is a very evolving field. There are new evolutionary technologies and invention being made. So the field is a fast moving field, it's a very flexible field. The regulations, the laws, the policies providing governance and guidance in the patent system should be evolving as a fast moving pace. So patent laws needs to be right at the head of technology, and specifically new technology and cutting edge technology technological advancement. Patent law need to be at the head, not at the back, because in order to provide governance to patent technological advancement or innovations and creativity, the law needs to be at the head of the technical field, that it is evolving to the extent that new technologies cannot leave leave the canopy or the governing structure of the patent system. So the patent laws of a country, of a region, internationally need to be moving at a very fast pace, and they need to be evolving at the level that technology is evolving. So patent the patent fee is a very inclusive field. So it doesn't really it's not that exclusive that specific individuals with specific qualifications need to be it requires certain qualification for you to partake within the patent space. So the patent space or the patent field or the patent system is a very inclusive space to work in. You can have a background in like myself, I have a background in management, background in political science. You can have a background in English literature, whatsoever academic background you come from. You can still have a chance at working in a patent space, maybe as a patent examiner, a patent manager, or patent lawyer, or certain professional contribution can be made in that direction. There have also been debates within the lens piece of patent protection that engineers are the most preferred professionals or qualification that is required to work as a patent examiner or patent lawyer. If you have an engineering background, then you are best suited for the patent field. But I disagree with that. I think some of the best patent lawyers, patent managers, or those working in the patent space and patent examiners are those that study other professional degrees and orientations that have not attached to engineering. So the patent is an inclusive space that requires the involvement of everybody. What it takes is You as an individual, your willingness to delve into the patent law, patent regulations, be it from your country or from a regional perspective or internationally, your willingness to understand the law, your willingness to know the laws to your fingertips. This is what is required to work in the patent space. So the patent field is a very inclusive and broad field. So like I said, the patent law needs to be exactly where technology is to serve its function. Functional patent law or an effective and efficient patent law needs to be exactly where technology is. Like I spoke about artificial intelligence, nanotechnology, and all of the new technological futures and advancement that is being made. The patent law need to be exactly where technology is. So you have an outdated patent law that is not effective, doesn't conform to the current day realities of technology or advancement. That law needs to be amended or enhanced to the extent that it addresses exactly what is going on in the patent space. It addresses issues related to artificial intelligence. It addresses issues related to nanotechnology, and it addresses issues related to biotechnology. So the patent laws need to be very flexible. It needs to be exactly where technology is to meet its effectiveness and functionality as as a law or as a regulation. So that is basically the essential of what patent law is and how useful patent law can be in any given society. So the patent law is an effective tool for societal advancement because it's the law of innovation. Patent law is the law of innovation. So it needs to be exactly where technology is, and it needs to be effective in providing the governance that is required for patent protection. So, like I said, it's a very broad field. It doesn't, as an individual, you don't have to have a background in engineering to work in this field. You can have a background in other fields or management, accounting, political science, or whatever background you have. But it requires your willingness to understand the laws, the policy, the regulation that governs patent protections, that promotes patent, that manage patents. So if you understand these regulations and laws, you go through several trainings, professional trainings. You can really adapt to that field and work as an effective patent lawyer, uh, patent examiner, patent manager, and work effectively in that direction. So a patent law embodies a lot of fields. If you are working uh, with tax, if you are working in public health, you are working in transportation, you are working in administration, there, there is or a level of patent that is involved in whatsoever field or technical background you are engaged. If you are in IT, you have a much higher involvement of patents and intellectual property. So that is that is what I would like to cover for what is the significance, what makes patent relevant as a field. So so like I said, if you have a deep interest and willingness to engage in technology, to understand the patent laws, the patent regulations, and you can be a very successful patent practitioner. Why is why is the patent law relevant? What makes it worthy of being used by a society? Why is the patent law important? What is its significance? So we want to discuss that the importance and the relevance of patent. So as an individual working within the patent system, take for example, you are a patent lawyer, you are a patent examiner, or you work at an intellectual property office, and you want to understand those working within that sector, how important is their contribution to the governance of innovation and creativity. So let read into that. What make their role very important. So as a as someone working in the patent field, what make your role relevant is that you are serving as a very special translator. Uh, you are serving as a translator for the law in different languages, specifically patent examiners that work at the national level, regional level, and particularly international level. So you are a translator of the law in different languages. You have to speak with those working in in the courts, the lawyers, the judges. You have to speak to them, to relate to them, for them to understand your approach to patent governance and how effective you are as maybe a patent examiner. You have to speak to a diverse followings of people, people working in government, people working in business. You have to speak to your clients for them to understand their innovation and how it can be protected. You have to serve as an advisor, advising clients, advising those in government, those in the private sector on how to use the patent law and how effective is the patent system, what benefits are there if they intend to engage in innovative venture or in business venture or commercial venture. What are the benefits? You need to speak. Also, you also serve as a translator to the juries. If you are a patent lawyer, you work in the courts, you are there to enforce your client's patent rights. You are there to provide protection, and you are litigating on behalf of a client. You need to speak in a way to the jurors that if your client patent or innovation have been infringed, if the rights and privileges have been infringed, you need to speak to different views and followings of people on how significant and important patent is from the government perspective, from private sector, and other stakeholders within the patent system. So you are serving as a special translator. You need to break the law down into plain language for someone that is not of or doesn't have uh, critical knowledge of what patent is and what patent serve to accomplish. So you have to break it down to the understanding of an ordinary individual that is in the public. You have to break the law down. You have to understand the marketing and the business objective of how patent enforcement or patent right can be quite significant to ensuring that a business is successful. So you have to speak to the marketing as well as the business objective of a client regarding options and opportunity within the patent system. If they intend to protect a patent or apply for patent protection within specific country, specific regions, you have to dissect the law within those countries and regions and provide advice, pieces of advice to your clients on how they can use the patent system to protect their invention or creation within in specific territorial confinement. So you need to do that. You have to have a clear and deeper understanding of how patent works. You also have to understand the creative process of investing your time and resources in producing an invention for the well-being and the forward march of society. So the creative process of invention, the creative process of ensuring when you have an invention, how to apply for patent protection within specific territorial confinement and what laws and regulations you need to follow and all of that. You need to understand that and know the creative process when you need to use time to intervene in uh, patent protection, invention, when you need to observe the space and take a pause and observe the patent space and not engage, and when you need to step out and engage with patent protection or patent patent development. If you are providing a service or if you have a product that is already making success in a market and you want to move to another market to apply for patent protection, what is required, what you need, what laws and regulations are stipulated there for you to follow, what are your obligations, and what, if you meet those obligations, what would be the benefit you stand to accrue from participating in the patent system. Take, for example, in the United States or in the European Union, if you wish to sell your product or have a service provided within that space. So you have to understand, you have to be a translator of the law, to speak to diverse views of people, to provide advice, to understand the creative process, to have a deeper understanding of the laws and regulations. So that is the significance of a contribution of someone working within the patent field, be it a patent examiner, a patent lawyer, a manager in an administrative post, ensuring that they facilitate the governance of innovation and creativity. So now we move into what is a patent. What is a patent? It's a very critical question to understand what it is a patent. So a patent basically is a legal right to prevent others from exploiting your invention. A patent is a legal right that uh, enables an inventor, be it an individual or a company, that right as a patent holder enables you to prevent other from exploiting your invention. So you came out with a new idea or you produce a new product, you went to the European Union and you apply for patent protection, you are granted patent protection, you are the legitimate holder of a patent that covers a specific product. The right that is given is the right you have to prevent others from exploiting your invention. So that is the right. Patent right enables an inventor, an, an inventor or an innovator give him or her the right to prevent others from exploiting their invention. So that right to prevent, uh, to stop, to prohibit others from exploiting your innovation can also mean the right to stop others from manufacturing a product that you came up with. You have the right to prevent others from manufacturing, say, a product if it's an if is if that could be maybe a service. You have the right to prevent others from providing said service to the public. And you also have the right to the usage of intervention. So the usage of intervention is, uh, take for example, you have a patent right over a specific product, and someone wants to use that product or sell that product. That person's the patent right give you the right to have a negotiation on the person to negotiate with you on how they intend to sell your product, and you guys can have can derive at an agreement on what be it through patent fees or royalties. You have the right to determine the nature of a contract between as a licensor to a licensee. So that relationship, the patent right give you the right to make a determination on whoever uses your product or services. So patent right also uh, give you the right to prevent others from using a method of manufacturing. A method of manufacturing could be a specific approach to producing your product. What methods, what approach, what step by step requirement that is needed to produce this specific product that you hold or right to as an inventor or patent holder. So you have the right to stop others from manufacturing your product. If they want to use it, you have the right to make a determination on how they can use it through a contract, and the financial benefits you can accrue from that through royalty or fees. So there are a lot of rights attached uh, to patents, specifically for patents holders. And you can also make a determination on the software process, because a product could not only be a physical product, but it could be an intellectual product with an invention, a tangible asset attached to it. So the method of production, you have the ability to prevent others from using that method. You also have the ability to stopping other people from using your software process. So if you made an invention, let's say a smartphone that have some software process that is required for its usage, that specific process can be you can restrict others from using that process, and and it's a right that is given to you as a patent holder. So there are a lot of rights and privileges attached to being a patent holder. Uh, it can be a determination of selling, reselling, restricting others from manufacturing, method of manufacturing, the software process, and all of that. A lot of rights and privileges attached to patents. So patent is a very critical tool, and it requires a lot of rights. It comes with a lot of rights and privileges. Even the approach to the sale of the sale intervention. The sale intervention is where, like I said, if someone want to use your product or your service. As a patent holder, you can make a determination on the sale intervention. You can make a determination on the software process, the method of the method of the method of manufacturing, and you can make a determination on the usage intervention also. So so there are a lot of privileges that come with being a patent holder. So we like to move quickly to make progress. So if what how long does a patent last? So a patent generally lasts for 20 years. Generally lasts for 20 years. So this right is given to you for a period of 20 years. There are some other varieties of duration, but generally most countries made a determination to use 20 years for a patent right. So as a patent holder, when you submit your application, uh, you file in your application to the patent office and you are granted uh, patent protection within a specific territory, region, or internationally. You have 20 years of protection until the patent falls into the public domain. So you are given 20 years uh, uh, as 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 an inventor and as a patent holder, be it an individual or company, you are given 20 years of protection uh, that will cover your patent within a specific region or internationally. So, what makes a patent special? There are other rights that can be given to a creator. We have uh, we have patent rights, we have copyrights, we have trademark, we have trade secret, we have traditional knowledge, we have a lot of rights and privileges within the intellectual property and field that can be given to those engaging in innovative ventures. So what makes a patent right different from other rights and privileges? We know it's a right given to an inventor that which which enables him to restrict others from exploiting his innovation, but and it lasts for 20 years before it falls into the public domain. But what makes a patent right special? So a patent right has what we refer to as strict liability claim. So patent right has a strict liability claim. So what that means is that you are strictly liable as an infringer, whether you knew the patent, uh, whether you knew you infringe on a patent or not. So a patent right is a very distinct right because it allows and ensure that whosoever infringes on a patent right has a strict liability. So whether the person, the individual, or the company knew that you was a holder or you are a holder to a patent right, whether they knew or not, as long as they infringed on your patent right, they are strictly liable. So there's no excuse to say we were not aware of this. We're not aware that you had uh, a right to this patent or a right to this product or a right to this service, irrespective of the I can say ignorance or lack of information to that effect that a company holds a patent or an individual holds a patent, you are strictly liable as an infringer, uh, because the question then would be, did you sell an invention that was covered by someone else's patent? Did you use a process that was covered by someone else's patent? So if you did, you are liable for a patent infringement. So that is the act of infringement. If you knew or not, you are liable for infringing an existing patent. So that's what makes patent right different from other rights, rights that is granted to inventors. So in other contexts like copyright, is a little bit different from that of patent right, because in copyright it's about unauthorized copying. Copyright deals with unauthorized copying. So take for example, if I independently as a creator uh, wrote the 48 Laws of Power by Robert Greene. I was somewhere in Liberia. I was in the Bokonima jungle, somewhere in central Liberia, Bon County, in a thick rainforest. I never knew about Robert Greene. I never knew about the 48 Laws of Power, but I independently developed uh, the 48 laws of power while I was in the jungle, the rainforest in Bokonima, central Liberia. I, I wrote the 48 laws of power. Unbeknownst to the fact that Robert Greene have already written and holds a copyright on the 48 laws of power. I won't be affected on a copyright because I didn't have any idea or knowledge that someone else's have previously written, said book for the 8 laws of power. So I didn't infringe, I didn't copy his work. I independently developed his work. So under copyright, I am free. Uh, I'm not liable. I cannot be affected by the law in this case because I have no idea that Robert Greene wrote the 48 laws of power. So unauthorized copying, if you copy someone's work, you knew they existed, you went knowing fully well it existed and you know the author and you wrote that book and you try to steal uh, the creation of someone else. It's unauthorized copy. But in a case where you didn't know, you had no idea, and it can be proven you have no prior knowledge, you were somewhere in Liberia, Bogonima Forest, in the middle of the forest, you managed to write the 48 laws of power. The 48 laws of power, you cannot be liable for copyright infringement. So that is clear. That is the difference. So on the contrary, in patent law, if I independently, develop a product, if I independently develop a service that someone else's has patent right holds a patent right to, if I independently use a, a process that someone has patent right to. If I independently develop a method or software process that someone someone has someone patent right covers, I am directly liable for patent infringement. So it doesn't matter if I knew that you had a patent right over a specific goods, product, commodity, or service, as long as I infringed or I used that I sell, I manufacture, or I produce someone's process or method that is covered by someone else's patent have infringed. So the patent law is a much stronger law. It's because it's a law that have strict liability. It's, it comes with a strict liability claim. So whether you knew it existed or not, you are liable under the law. That's what makes the patent law much stronger and very critical as a law. So if you are a patent holder, you carry a lot of power in making a determination on who use who can exploit your patent. And that's why the term, if you have background knowledge, that's why the term, the duration of patent protection is a much shorter as compared to other rights, copyrights that have 50 years, other have 25, and it's a much shorter time period because patent law is much stronger. So without patent, there's no protection for innovation. Void of the patent law, there will be no protection for innovation. There will be no advantage to produce new inventions or produce technological services. No incentive for coming up with new and ingenious ideas. There will be no ownership and control of inventions, of creative ventures. So patent law ensures that if you invest your time and your resources and you came up with an innovation that is very productive to society, and patent law ensures that as an individual, an innovator, you are rewarded for your time, your resources, you place you place within that production of invention. So patent law serves as a reward for making available a new product, a new device, a new service, entertaining, pharmaceutical, whatsoever, a variety of fees that you engage in patent protection. Patent law ensures that you are incentivized to continue to produce new invention. So patent law serves as an incentive or reward from society that is granted to an inventor that gives him the right to restrict others from exploiting his product or service. And it also comes with a financial reward as well, because it allows you to restrict others from using your service. And financially, you can determine who will sell your product. You can make a determination on what the arrangement would be if the person intends to have a contract with you to sell your product elsewhere. So that is the strength of the patent law. The patent law is a very critical tool that is required in any given society to, to provide incentive for the continuation of new inventions, of new services, and the proliferation of new devices that will improve the quality of life of any society. So the patent, what what makes the patent necessary? What makes patent necessary in any given society or in any given venture? Uh, to develop technologies and have the ability to sell it to consumers. There's a financial incentive attached to that. So patent law is very necessary for the progress of any society. So the uniqueness of ideas and invention. Any given society will require patent protection to not only be productive and have innovations internally, but to be able to compete regionally and internationally with other countries that are engaged in technological advancement, the production of new and cutting edge technologies. So patent law is very, very, very significant and necessary for the forward march of society because it cultivates an exchange of ideas, an exchange of service for the betterment of society in return for a financial incentive. It could be also recognition. So there are a lot of necessity for patent protection within any given society. So let's discuss the nature of ideas. The nature of ideas. So in a natural state where void of patent laws, patent regulations, and policies, in a natural state, any idea, the nature of idea is wherein um, uh, one thing, uh, an idea, if you have a brilliant idea and you kept that idea in your mind, it's exclusive to you as an individual, the bearer of said idea. So it's natural that we have ingenious ideas and we can come up with new and innovative ways to improve processes, to improve methods, to improve just in general a variety of fields that society requires to make progress. So in a natural state, you can have an idea, a very brilliant idea, and it's in your mind, and you keep that idea to yourself. You as an individual, the bearer of that idea, you are the exclusive owner of said idea. And you can keep the idea for yourself in your mind. You can exclusively possess it. But the moment you diverge that idea, you disclose the idea. If I take, for example, if I had a brilliant idea and I diverge that idea to my audience, I disclose that brilliant idea to my audience, the moment I use it to make a service or a product that embodies that idea is no longer my idea. It's an idea that has been shared with 1, 2, or 3 person is an idea that's been shared with my audience. So I'm no longer in exclusive possession of that idea because I've taken that idea from my mind and I've shared it with you. You are in possession of the entirety or certain degree of the idea, and another person that is following is also in possession of said idea that I've just shared with my audience. So it becomes that idea then becomes an inclusive idea. It's not exclusive to me. So everyone has a shared understanding of that idea. And if I go further and produce a service or a product that embodies that idea, everyone that encounter that product or service can no longer be disposed of said idea. So is ideas germinates, it spreads around, it illuminates those that it encounters or those that encounter it. So in a natural state, void of pattern laws, patent protection, an idea is only yours when you keep it within your mind. As long as you disclose it, as long as you diverge it, it becomes inclusive. Everyone has a level, a degree of ownership to said ideas. So John may have an understanding of the idea I share. Paul may have an understanding, and we all have, some might have an entirety of the idea, understanding of the idea, and some might have a degree of 50 or 60%, but the idea have been shared with my audience. So it's no longer my exclusive idea, it's an inclusive idea that have been shared with everyone. And I'm not in a position to dispossess myself of it or anyone else from that idea. Take, for example, I had a brilliant idea on getting 1 million views on Facebook within 1 hour. And I share that idea with you guys. These are the steps that is required to get 1 million views in 1 hour on Facebook. And everybody is illuminated by the idea. It's very interesting. It's very intriguing. It's a brilliant idea. How did he come up with this brilliant idea? So everybody is intrigued. Everybody is illuminated by a brilliant idea. So that's how idea works within the natural state. As long as you share an idea, we all have the entirety of the idea, and everybody is illuminated by the idea because of a productive idea. And it's like passing a torchlight. Everyone is illuminated in the dark. When you have a candle, like I light your candle, you light mine, and everyone is illuminated by an idea. So that is in a natural state, void of patent protection and patent law. So this is in a natural state, like I said, void of any legal intervention. There's no patent law, there's no patent protection. So this is in this natural state that patent laws, patent policies and regulations comes in. This is what makes patent critical, because in the natural state, you have no way of protecting your idea. You have no way of protecting an ingenious, a brilliant idea. So patent law now ensure that if you had a brilliant idea, if I had, or if I have a brilliant idea, how to generate 1 million views within 1 hour on Facebook, and I share that idea through a step description with my audience, and everyone is inclusive of the step-by-step approach that is required to get 1 million views within 1 hour, and everyone is using that approach. Patent laws enable me to share the idea, but to also be able to protect and to restrict others from using my idea. So I'm out of the natural state, I'm into the legal state with an intervention of patent law, where patent protects me even if I've had the opportunity to share my idea with you guys. But the patent law ensures that I can disclose my idea to the world. Many can learn of my idea, many can be intrigued and illuminated by my idea, but patent law gave me a temporary exclusive right to prevent others from exploiting, from using my idea or invention. So that's the distinction of patent law. Patent law ensures that an idea that is in the natural state have the ability to be shared worldwide, to be shared with this audience. But irrespective of me sharing my ideas with my audience and globally, I still have the right to restrict, to stop others from using whatever methods, whatever process, whatever approach I use. I can stop any individual once I have a patent right. I'm legally a patent holder. Patent law gives me the right to restrict other and prevent other from using my idea for a period of 20 years. So in 20 years, I'll have the right to restrict, to prevent others from exploiting my idea or my innovation. So that is the significance of the patent law and the patent system that ensures the protection, the development, and the promotion of creativity and innovations. So we move now to what is an invention. We have discussed what is a patent. Now we are moving to what is an invention. So firstly, an invention is an intangible asset. An invention is intangible, meaning we cannot feel it, hold it, or touch it. It's abstract. An invention is abstract, it's an intangible asset. So it's a form, an invention is a form of intellectual property to be distinguished from real property. Let me go back on that again. What is an invention? An invention is intangible asset. It's an asset that is intangible in the sense that we cannot feel it, touch it, or hold it. It's intangible. And it's a form of intellectual property to be distinguished from real property. So that's what an invention is. So for typical example, I would like to do this illustration. This is an iPhone Pro Max 13. And so this is a typical invention, a smartphone, as an invention. So this have some physical as well as intangible feature. So as to distinguish from real property, this Phone has a platinum surrounding. You have cameras. You have microphones. You have a lot of physical properties, but it's also an invention. We have we have programs. We have a lot of software algorithms on it. So it's also an intangible asset. It's a form of intellectual property to be distinguished from real property. So, like I gave the example of the iPhone. Uh, so if I was imposed, is if I decided to give this iPhone to a friend, and as and I told the friend to be, it's a gift. Maybe a birthday, I give it to you as a gift. So it's a physical property that I've given to him. And as long as he or she is in possession of that physical property as an iPhone, I no longer, I'm no longer in possession of it. And that means it's no longer in my possession. It is in his possession as a physical property. So he can only own it, that physical property, as an iPhone at a time, and I can only be in possession of it at a particular time, this specific and identical iPhone. So we both cannot be in possession of it at the same time. On the contrary, an invention, an invention using the same iPhone, an invention in contrast is not a physical thing, because we all can possess an idea of what? A smartphone. The idea that I can use a smartphone to call someone, uh, to write a message, to take pictures, lot of services that can be used on an iPhone. So the idea of having uh, an iPhone uh, is intangible. It's an idea that we all can relate to as phones holder or smartphones holder, or those in possession of iPhones. So it's the idea of an invention at once. We all, as iPhone holders or as smartphone holders or as phone holders, can understand that the concept and the idea of having a phone is basically to make calls, to receive calls, to send messages, to receive messages, and a lot of other services. But generally, this is the broad idea of having a phone. So an invention is the concept, is the technical knowledge. It's not the physical property, but it's the intangible idea, concept of, or technical information that an invention embodies. And it have the phone, using this continual example, the iPhone has electronics, it have software algorithms, it have microphone, it have cameras. So there are a lot of features and characteristics of an intangible smartphone. And if I am the first person that created a smartphone, not did not only produce the product, which is the physical property, but they also created that that invention, that concept, or that new idea that smartphone has specific characteristic, specific features. It can take pictures, send pictures, it can receive calls on the internet. So the first person that produced a smartphone didn't only produce the product of a smartphone, but it was the first individual or company that produced the concept, the idea of smartphone. So this is what we call invention. An invention is intangible. It's intangible. You cannot, it's not a physical property. It's a form of intellectual property to be distinguished from real property. So is the concept is characterized by abstract qualities, is concept, is ideas, is technical information. An invention, another characteristic of an invention is inexhaustible, meaning because it is a concept, it is unlimited. It's infinite. It's not a scarce resource like gasoline or wheat or beef or some other essential commodity. An invention is inexhaustible. It cannot be used up. It cannot be depleted. It's not a depleted resource. It's not a scarce resource. It's is inexhaustible. See, it's a concept, it's an idea, it's always existing, it's infinite. So that is one of the characteristic of an invention. An invention is inexhaustible. An invention is not excludable. An invention is not excludable. What that means, what that means is that in the absence of patent law, one justification of legal intervention is time and resources. So for those working in the pharmaceutical industry, there are a lot of billions of dollars to produce uh, a drug, maybe a tablet or a single tablet that comes from the factory, that's in the pharmacy. It could be so simple. Maybe you buy one pack for $5 or $10 or $2 to $3, depending on the kind of drug. But the production, the investment, the resources, the time invested in producing that drug costs billions of dollars. So is a critical investment that is being made, and is one of the characterization of invention. An invention is not excludable, and it's not excludable because and the justification is that without patent, there's no incentive to create. No, is not excludable in a sense that an invention, you cannot exclude others from using it without patent law. If there were no patent law, uh, and I happen to invest time and resources in producing a drug, maybe for cancer treatment, I took billions in dollars and invested it. So without patent law, I cannot exclude other from maybe piggybacking on my invention to produce their new invention. But the amount of investment, the time and billions of dollars are made in that invention and produce the information, and someone use that, store that information to produce the drug, it will take them less, a very minimal amount as compared to what I initially invested on the front end to produce that drug. So without patent law, inventions are non-excludable. You cannot prevent others or exclude others from exploiting your invention without patent laws. That is the clarification I wanted to make. So inventions are non-excludable. So without patent law, there is no incentive to create. There's no incentive to innovate. There's a rational decision to not innovate, just copy. Don't make all the front end investment of years and billions of dollars in specific product, come out with specific product. Just wait when other created, you steal it, or because there's no patent law to protect it, you use that information and produce maybe something new or something similar or the exact same. So in the context void of patent law, inventions are non-excludable. So, but with patent law, with patent protection, you can exclude others from using your inventions. So there will be no copying because patent law prohibits the exploitation, the copying, the usage, the selling, the reselling, the method, the process, everything that requires the protection of an existing invention. That is why patent law protects. So patent right is an indicative right. Patent right is an indicative right, meaning it doesn't give me the right to make or sell. You see, patent law doesn't give me the right to make or to sell. It's an indicative right. Patent right only gave me the right to prevent others from exploiting my invention. I came up with a very brilliant product. Uh, this earpiece attached with the microphone. So I came up with this very significant and important product. It's nice to use. It has different feature. You know, I can put the volume up, put the volume down. I don't need to have anything. There's no connection. It's a Bluetooth. So it's a very innovative product. So patent right doesn't give me the right to put this on the market, to produce it, to manufacture it. It doesn't give me the right to sell it. Patent right or patent law only give me the right to prevent others from exploiting, from manufacturing, from producing, from selling my invention. Other laws give me the right to make and sell. So if I had a new invention, a brilliant idea, I went to the patent office, I gave a description of my patent. I came up with a very good device or this drug for cancer treatment. And this is the description of what it takes, how I made it. These are the information. I went to the patent office. Take, for example, maybe in Geneva to register, and they went through all, the patent examiner went through all the steps, look at all the laws and regulations stipulated and show, yes, I met all the requirements and I was granted a patent. What that right gave me as a patent holder is the right to prevent others from using my innovation or my service, my innovative service. That is the right the law, patent law gives me the right to prevent others from using my invention. It doesn't necessarily give me the right to sell or to make, to produce, to manufacture. No. Other laws give me the right to manufacture, to sell, to produce. So, what are these laws that give me the right to manufacture a product? Commercial laws and regulations. So, I go to a specific country, maybe the US, maybe France. I was granted patent right. I apply for patent protection, international patent protection in Geneva. Here is my right. I want to produce this. I have to meet the commercial laws and regulations within said country in order to commercialize my product. I have to meet up. There are several laws. I have to meet up with safety laws and regulations. I have to meet the requirements of food and drugs regulations. Take, for example, continuing on the iPhone example, I have to meet telecommunications laws and regulations to be able to manufacture and sell phones. So patent law doesn't necessarily give me the right to make and sell. Patent law gives me the right to prevent others from exploiting my invention. Other laws give me the right to make and sell. Commercial laws, safety laws and regulation, food and drugs regulation, telecommunication, pharmaceutical, biotechnology, nanotechnology, all these laws and regulations are, are pertaining a specific invention. I will need to go within a specific nation within their territorial confinement to seek and to meet the requirement that is laid out for commercial laws, for all these laws and regulations in order to meet them, those requirements spelled out before I'm granted the right to make and sell. So that is the difference. That is the difference because we have to make that very clear and distinct that patent laws doesn't give any individual, an inventor or innovator or company the right to make and sell. All it does is it gives the right to prevent others from exploiting, from making, selling, using your invention. Other laws within a specific territorial region or internationally, commercial laws, safety laws, food, drugs, telecommunication, pharmaceutical, biotechnology, all these laws give you the right to make and sell. So that's the distinction that I wanted to make. If you are, if you came out with a new phone and you file for a patent application, you are granted patent, you are granted a patent, you are legitimate patent holder, you need to go to a specific territory like France, like Italy, and you meet the telecommunications laws and regulation within that's the territorial confinement. You meet the laws and regulations, the stipulated requirements as a phone producer, and the laws might set the sale of cell phone, maybe the battery, the quality of the battery, if it's overheating or if it explodes, and all those regulations that ensures there are proper guidelines in place for safety. Uh, you meet them within the telecommunications as well as the safety law of those countries. And then you are given a right to make and sell. Then you can set up a factory or production facility or manufacturing facility or service center where you can for products make and sell. So that is the distinction that you need to make between patent law and other laws. So I just want to go now and move into the justifications of patents. How, why is patent worthy of being protected? How can we justify patent protection? So that is what I want to move to and discuss. So in a natural, so it's just natural. It's a natural phenomenon, and patent is a natural right you, that someone is giving patent protection. If I created a specific device, if I created or produce uh, a specific drug, it's just natural. Since I created it, I should be given right to it. So naturally, I created it, I should own it. So societies as a whole, in general, from different perspective, also societies say, since you were you was able to invest your time, your resources, your knowledge, and you came up with a device, you came up with a drug that treats cancer, that treats a specific disease. It's just right as a society, since you created it, that we give you ownership for being the creator. It's just natural that we do that. So patent right is one of the justification is that because you created it, so you should have the right to it. You should own it. So it's a reward from society. Society thanking you as an inventor that for bringing something forth to society that benefits, that is of market value, for bringing something forth that is of financial benefit to the society, to improve the quality of life, to improve entertainment, to improve the way, to improve health, to improve any variety of technological field. It's just right that we reward you with a patent. So the way that a society reward an inventor is to give them a patent right. Give you this right that you have the ability to restrict and prevent others from using your invention for a period of 20 years. And after the expiration of that patent, the patent then falls into the public domain and everyone can have access to it. So that is one of the justification for patent protection, that we need to reward inventors, we need to reward innovators, to serve as an incentive that they continue to move on that path of producing new invention for the forward march of society, to improve health, to improve entertainment, pharmaceutical, transportation, aerospace, all these varieties of fields that requires certain level of technological advancement. So a patent right is a reward to an inventor. Another justification could be or quid pro, or means me pronounce it rightly, or quid pro quo, or disclosure theory. So another justification for patent is or quid pro quo, or disclosure theory. So a quid pro quo, what that means is this for that. If you give me this, I give you that. So it's a this for that. Society and the innovator are engaged in or this for that. If you come up and develop and produce a new invention, uh, and Instead of keeping that brilliant idea in your mind and keeping it, possessing it all by yourself, we are encouraging you to disclose it uh, and produce something that we all can enjoy as a society and benefit from. And we are giving you a protection of 20 years. And after 20 years, you can give us all the information. You can disclose that information to the society. This is the step. These are the requirements I use to make this device, this product, and these are the steps. And that will fall in the general and the public domain, and anyone can use that information to advance on it or to produce similar devices or medication or drug. So it's a quid pro quo. The society wants information from the patent or the patent holder or the inventor in exchange for 20 years protection and financial incentive. And the society in returns get the information the inventor has, the technical knowledge and technical information the presenter has, that will fall into public domain that everyone else can benefit from and can use that information to improve on and produce new invention devices and drugs. So this is a quid pro quo or tit for tat or disclosure theory. So you have a brilliant idea. Society is begging you, please don't keep that your brilliant idea in your mind. Share it with me. I'm going to protect it for 20 years. And after 20 years, you can give me that idea so I can give it to every citizen or inhabitants to ensure that more people can use that idea, can improve on it, or use that idea to have new drugs, new devices within a society. So a tit for tat, this for that. So that is one of the justification for patent protection. Share your idea with the world in return for patent rights. Uh, so after 20 years, anyone can use it. 20 years, you benefit from it. Uh, you can sell the product. You can you can prevent others from using it. So that is the exchange. That's another justification for patent protection. So these are some of the justification for patent protection. Now we would like to make progress and move into what we call a monopoly profit. We often hear about monopoly profit. What is a monopoly? So if you own a patent and you have the ability to exclude others from entering the market, then you have a competitive advantage because only you can determine who use your patent. Only you can uh, derive a contract or license someone to use your patent. So you have a competitive market advantage. You can make a determination on who to license and who not to license. So there's a lot of power involved in a patent. The only providers of a technology within a market for 20 years. So if you have a specific product or service that there are not many alternatives to, or there are few alternatives to, you have a very strong power of bargaining chip as a pattern to make a determination for the going 20 years on uh, what who to sell to, how to manufacture, the process, the procedures, and how to collect royalties if you make a determination on who to sell to. So all that is a very strong market power. And in terms of the pricing of that product or that drug you came off with, uh, if if it's a very specialty drug that there are not many options to buy or to buy from within that market. But there are few alternatives. But you happen to be one of those alternatives, and your drug is very effective in curing, in managing certain diseases. So you have a market power. So not that you can make a determination on the pricing, but you have a level of negotiation power to make a determination on the pricing. Although there are other forces, market power may demands determine on how to make that determination. Supply and demand. How many people need our drugs and how many persons can afford it within a specific market. And there will be some level of government intervention determining on if that government is part and parcel a member of the World Trade Organization. There are specific requirements that need to be followed, and if not, there are other requirements and determination that need to be made. But it's a very powerful thing to have a patent. Uh, and depending on the type of patent you have, you might have market power. And not just having market power, but having market power for 20 years. So it's a very critical right to have as a patent holder, and depending on what your invention or your service is, you can exploit that right to the maximum and get out of it all the financial benefit that is required. And even before the 20-year elapse, there are a lot of things that can be done and achieved as a patent holder. Now, also, there are also other ways to encourage innovation. There are other ways apart from patent protection that people can encourage innovation. And one of that particular way is trade secret. So trade secret is the opposite spectrum. Trade secret is the opposite spectrum of patent protection. Trade secret says if you have an inventive way of protecting your innovation, you can keep that secret to yourself, and we as a government will still give you protection. And we give you protection. Patent, patent on the contrary say if you have a secret to yourself, if you have an idea, share that idea with us. We give you protection for 20 years, and after 20 years, the idea then fall into the public domains for the general public to have access to it. On the contrary, trade secret says if you have a brilliant idea, keep that idea secret to yourself. We will protect you. If somebody went into your database and take, for example, store the formula for Coca-Cola. Very interesting. Coca-Cola, that happens to be one of the, if not arguably, the most productive, financially lucrative company in the world, Coca-Cola. So government is saying in trade secret, if you have a secret, an idea, and you have a secret protecting that idea, we as a government give you protection, keeping it secret. So if someone, maybe an employee or someone, went into your database and stole your formula for Coca-Cola, we as a government will intervene on your behalf and restore your right to keep that secret and keep that idea secret or keep that formula secret. So billion-dollar company like Coca-Cola, and one of my professors or lecturers told us as a class that the formulas of Coca-Cola are not kept by a single individual. There are several individuals for different component of the formula. Uh, Mr. John might have component A, B of the formula. Edward have B, C, D, and another person have E, F, and G. So it's not in one individual hand, and that's what make Coca-Cola not only a very lucrative company, but it has the ability to keep that trade secret to itself, and that no one else know the formula. So that's one way of encouraging innovation. Another way of encouraging innovation is research, through research, the provision of research grants. So we have universities, we have scholarly and academic institutions within our countries, our societies. And if we want to encourage people to innovate and come up with new ideas, the government have to take the responsibility to apportion certain fundings, maybe for cancer treatment, for this disease treatment, for new innovation, new devices. The government has to take on the responsibility, or other private institutions, philanthropic foundations, take on the responsibility to mobilize and come up with fundings, uh, and make those funding available for researchers to compete. Bring your idea, and if your idea meet the requirements to be granted, to be given a grant, then you will receive a grant to innovate, to make research on producing new inventions and making new inventions available for the public. So that's another way of encouraging innovation. Apart from trade secret, we have research grant. Another way of encouraging innovation is through awards. And one of the critical awards that is always used to motivate researchers, academics to innovate and come up with new idea is the Nobel Peace Prize. So the Nobel Prize is a very distinct and critical institution that is globally there to provide professional recognition as well as financial incentive for people to innovate, to come up with new inventions. There are other fees for peace, for security, but most importantly, I would like to focus on the innovative space. Those involved in academic institutions that are doing research, that coming up with new inventions, and they are being awarded. Uh, it's not only the $1 million that is attached to the Nobel Prize, but the professional recognition that is gained when that award is given to an individual or someone from an academic background, academic researcher, or an inventor. So these are other ways to encourage innovation. So I would just like to piggyback on monopoly profit. Piggybacking on monopoly profit, the word monopoly can sometimes be very confusing, and it comes with a very negative connotation. Every time you hear about monopoly, you think about what comes to mind is the ability of one person to restrict maybe entirely the whole market from selling, producing, or making certain products or services. But to basically go into details is that most often people are confused when we hear the word monopoly or monopoly profit. So I want to further elaborate on what monopoly profit is. So, so the question is a patent a monopoly? Is a patent a monopoly? The answer is no. Absolutely no. A patent is not a monopoly. A patent gives the right to prevent others from exploiting your inventions, and that can potentially give rise to monopoly. So if I develop the first smartphone, I have I am the legal patent holder of the smartphone, and the market is my domain. I can determine who to lessen, to sell, or to manufacture, to use, to whatever that patent right gave me. I can make a determination within a specific market or globally on how that patent right is to be exploited. I can prevent others. I can prevent my competitors. I can determine who use it, who sell my product. So that is a very powerful right. So it doesn't absolutely, uh, a patent isn't absolutely a monopoly, but a patent has the potential to give rise to a monopoly. But apart from having a right to exclude order, there are other characteristics that needs to be attached to a specific company that makes that company a having that makes that company to have monopoly right over a specific market or globally. So a monopoly, what is a monopoly exactly? What is it? So a monopoly is basically the one and only provider of a service or a product and having the market power to influence pricing. Let me go over that. A monopoly is having is basically having or being the only provider of a specific goods or service and having the market power to influence pricing. So that what constitutes a monopoly. So there's a difference between a monopoly and a patent. A patent gives you the right. If you develop this microphone, you produce or manufacture this microphone, a patent gives you the right to prevent others from manufacturing, producing, selling, using the process, the mental, the software process, everything from producing or selling this microphone. On the contrary, there might be other alternatives. This is not the only microphone. There might be other alternatives to this microphone. Even if you are the major player within the market, but there are other alternatives that apart from your microphone, I have the option as a customer or consumer to go elsewhere and maybe with an even better price or better quality and to buy microphones, headphones from somewhere else. But in the case of a monopoly, it's quite different. In the case of a monopoly, you are the sole producer of headphones on the entire market. Let me just give a very typical example that most of you will be able to relate to. So let's say Liberia is a consumer of rice. Our staple in Liberia is rice. So if I own the company, if I was the sole distributor or importer, if I was the sole importer of rice on the Liberian market, no one else or no company, no individual and institution have the right to import rice within the territorial confinement, the economic market space of Liberia. That automatically makes me a monopoly, a company that is of monopolistic characteristic. So that makes me automatically a monopoly because I have the import permit, the right to import rice within a whole country. I'm the sole importer of rice in Liberia. So that will automatically make me a monopoly. Take, for example, I'm the only producer of this headphone. Take this headphone may be technological advanced country, could be France. In Brazil, I'm the only producer of headphones in totality. In Brazil, I'm the only producer of headphones in Brazil. Automatically, I'm operating a monopoly because what that make me is I have the power to influence pricing. So supply and demand also is involved, but and government involvement determine on what international organizations they are member to. So that is the distinction from a patent to a monopoly. A monopoly gives you the right, just to summarize, a monopoly this a monopoly basically a patent doesn't automatically makes you a monopoly because it only allows you to prevent others from exploiting your invention. On the contrary, a monopoly is wherein you are the sole provider of a product or service within a country, and you have the power to influence pricing. You can make a determination. Let's take, for example, back in the days, years ago, when Microsoft was the only producer of the Windows, Microsoft Windows or something. So everyone that needed to operate their business, government, institution, and you wanted to use the Windows system, Microsoft had 80 to 90% share of the market globally. So Microsoft, there were other alternatives coming up. I think Steve Jobs, they were working back then with other company. There were other alternatives, existing alternatives, but Microsoft had 80 to 90% share globally of the market value of the Windows. So automatically, Microsoft was a monopoly. So as the owner of the Windows operating system, uh, for those years, Microsoft operated a monopoly. So Microsoft years back, Microsoft can typically is a textbook example of a monopoly. So that's how I will put it. Microsoft is a typical example of a monopoly that existed in the past. It was not the only, but the most powerful alternative I could make, could influence pricing on the Windows operating system. So moving forward, we are about to conclude. I know this section was very, very, very long, but long and interesting. A lot. We are sharing a lot of information regarding patent, what is patent, what is innovation, and an overview of the patent system. So briefly, before we conclude, we'd like to cover that. So like we said, the patent doesn't automatically makes you a monopoly. There are a lot of other characteristics that that is required for a patent holder or company or an individual holding a patent to be referred to as a monopoly. That person should be the sole provider of a service or a product within a specific market and have the market share, the market power to influence pricing. So we discussed the Microsoft operating system, and Microsoft was a staple functional service that everybody, very effective service to operate, to administer a program, a project, to operate a bureaucratic service. You require the Microsoft operating system, even to run a business. So governmental wise, private sector, everybody needed the Microsoft system to have a functional operation. And so people needed it to run their businesses, to run the government, and there were not many alternatives. And Microsoft products were very distinct. So most people preferred it because of the service and the effectiveness and efficiency it offered back then. So there are other staple articles that can make a company or an individual monopolistic or to be referred to as a monopoly. So, like I spoke about in Liberia perspective, where rice is a staple, and if I was given the right to be a sole importer of rice within that market, I automatically becomes a monopoly. So that could be if depending on the country, if the staple is gasoline, is the staple gasoline another staple in Liberia and most other countries around the world. Another staple could be grain, especially for European country, grain and wheat. Ukraine is one of the dominant exporter of wheats and grains. So because of the war going on there, most of the war have been affected in terms of wheat and grain production and export globally. So that is the impact in this context now as a monopoly but a single country that have large output of production and exportation of grain. So there are similarities between how monopolies and affect uh, a specific country or regionally or internationally. So I would like to maybe come to a close on the state because I think I've taken wow, 3 hours. Wow. So thank you guys for following. Let me do a follow up before I end this. Let me check it up, check it up, check it up, check it up, check it up. Let me check on the feedback. Maybe I receive comments. Anything I need to address before I end this? Uh, so let me check it up. Let me check up your feedbacks and if there are comments or commendations. Uh, check your feedbacks. So if I need to respond to any comments, queries. Let me check to see your feedback if there are any comments and queries that I need to respond to. And guys, I have on this my to see your feedback. On this my I've posted my research papers. If you look on the post, uh, we talk about where it reads, Welcome to the second episode of the Intellectual Property and Trade Nexus podcast. Today we discuss topics centers on the below topics. No copyright. So today we never play song. I think we need to play something before we introduce as we look for the feedback. So we talk about the overview of patent law. What is patent? What is an invention? Then I said, please read my research paper. So I'd like for you guys to read my research papers. Yeah, on uh, SSRNM. So you guys can download them, my research paper. The ownership of artificial intelligence generated and created inventions. That were my research, my thesis paper for my Master of Laws in Intellectual Property when I studied at the University of Turin. These other research people, the WTO and food security in least developed countries. I think somewhere in 2021, I wrote this, basically giving my perspective with a lot of theses and anti-theses and a lot of research uh, backing up my argument that uh, food security requires some level of intellectual property intervention to ensure that the food system, the global food system, is effective for specifically those that need it the most, uh, developing and least developed countries that are the victims of food insecurity. So that's what the papers speak about. So I'd like for you guys to read my papers. Thank you for following. We'll see you for the next episode. Thank you, guys. Thank you for all the support. Continue to follow. This is the Intellectual Property and Trade Nexus podcast, a forum for innovations in trade. Thank you. I hope this time around our audio visual quality will be of one of the best quality. Thank you and bye. See you soon. See you later.